Hello, Ellen. My name is Mikesh, and I'm here to provide you with legal advice regarding your recent purchase of Pineview Cottage. I'll break down the key issues simply and straightforwardly so you can understand your rights and the next steps. To recap, you purchased Pineview Cottage from Charles, and the transfer of ownership was successfully registered at the land registry. However, after taking possessions, two unexpected issues arose. The first being Tina claims she has a lease agreement with Charles, which allows her to stay in the property for another 5 years. And Charles' brother David has come forward saying he has an option to buy the property, which was agreed upon 3 years ago. Neither Tina's lease nor David's option to purchase was recorded in the land registry, which complicates the situation. Furthermore, Charles, as you know, is currently unavailable. In this presentation, I will address three important questions that help you understand your position. The first being that, does the Land Registration Act 2002 protect you as a registered proprietor? The second, can Tina's alleged lease bind you as the new owner? And finally, does David's option to purchase impact your ownership rights? Legal terms and concepts can be confusing, especially if you're unfamiliar with them. My goal today is to explain these issues clearly and in simple terms, using examples where possible. By the end, you will better understand your rights and what actions you might consider taking next. First, we must discuss the Land Registration Act 2002 and its purpose. The Land Registration Act 2002, also known as the LRA 2002, is designed to simplify property ownership and provide certainty to property buyers like you, Ellen. Registering a property with a land registry protects the owner's title, and ownership disputes are significantly reduced. Essentially, it acts as a public record that confirms who legally owns the land and any registered rights or restrictions affecting it. Under the LRA 2002, unregistered interests like Tina's lease and David's option to purchase do not bind you unless they qualify as overriding interests under Schedule 3, which will be discussed later. These protections offer certainty for buyers like you, ensuring that your title takes priority over unregistered claims that do not meet the legal requirements for overriding interests. The LRA 2002 offers key protections for registered proprietors like you, Ellen, such as Section 103 for indemnity for loss, which may provide recourse for you if you suffer loss due to errors or omissions in the land registry, or Schedule 4, the alteration of the register, which limits circumstances under which the register can be altered, reinforcing the security of your registered title unless fraud, a valid overriding interest, is proven. The key protections for you against Tina and David, however, can be found in Section 58, which states that the registered proprietor is deemed to hold a conclusive title to the property. It provides you with a strong presumption of ownership, protecting you from most claims unless they fall under specific exceptions like overriding interests outlined in Schedule 3. For example, in the case of Walker and Burton, the registered proprietor's title was upheld even though the registration process had issues. This confirmed the principle of indefeasibility under Section 58, emphasizing the conclusive nature of registered title unless fraud or an overriding interest can be proven. This provision is central to your case, as it establishes your primary legal position as a rightful owner of Pineview Cottage. Furthermore, under LRA 2002 that governs your priority of registered interest can be found in Section 29. This section establishes that a purchaser of registered title estate takes the land subject only to registered interest and overriding interest under Schedule 3. Unregistered interests that do not qualify as overriding interests generally lose priority and cannot bind the new owner. In your case, this provision ensures that your title has precedence over David's unregistered options to purchase unless it qualifies as an overriding interest. In summary, based on the provisions mentioned, it is clear that LRA 2002 provides adequate protection for registered proprietors like you, Alan. As previously mentioned, there are exceptions known as overriding interests. These are rights that might affect the property even if they're not registered. This is important because some overriding interests could impact your ownership of Pineview Cottage. In simplified terms, overriding interests are rights that are considered so important that the law protects them even if they are not registered. Under the LRA 2002, overriding interests may take effect against a first registered proprietor after compulsory or voluntary first registration of a title, or against a person who becomes the registered proprietor on the transfer of a title that is already registered, like you, Ellen. They are outlined in Schedule 3 of the Land Registration Act 2002. Among the overriding interests that may be relevant to the case is that of leases of 7 years or less, outlined in Schedule 3, Paragraph 1, rights of persons in actual occupation, which can be found in Paragraph 2, and equitable interests linked to actual occupation, also in Paragraph 2. Your registered title is generally protected, but you must consider what overriding interests apply to Tina or David and whether they meet the statutory requirements to bind you, which we will go into more detail in this presentation. Under the LRA 2002, your ownership is protected as the registered proprietor of Pineview Cottage. However, your title may be subject to overriding interests as mentioned, including unregistered rights arising from actual occupation. The relevant provisions are Schedule 3, Paragraph 1, which covers legal leases not exceeding 7 years, which automatically override the registration and bind the purchaser, and also Schedule 3, Paragraph 2, in which unregistered rights such as equitable leases or unprotected legal leases can override the registrar title if the person claiming the interest is in actual occupation. The occupation must have been obvious on a reasonably careful inspection of the land, or the purchaser knew about the interest. What this means is that Tina must prove that her lease was not exceeding 7 years, or she must prove that she was physically living or using the piece of land or the property in a way that is obvious to anyone who is inspecting it. Tina claims to have a lease agreement with Charles. If the lease is for 7 years or less, it might override automatically under Schedule 3, Paragraph 1, provided it is valid. If the lease is for more than 7 years, it must have been registered at the land registry to be binding. Tina's lease is unregistered, so she must rely on overriding interest under Schedule 3, Paragraph 2. Similarly, in the case of Ferrishurst Limited and Wallerside Limited, the tenant had a lease agreement, but the landlord sold the property without notifying the tenant. The new owner argued the lease was not binding because it was not registered. The court upheld that an unregistered lease of less than 7 years may bind a new owner provided it meets the necessary statutory requirements. As the case exemplifies, Tina had stayed on the property for 2 years and had an agreement for another 5 years, bringing the total years to 7 years. She may choose to argue on the facts that her lease is to be considered under Schedule 3, Paragraph 2 of the LRA 2002 as a valid overriding interest. To invoke Schedule 3, Paragraph 2, Tina must also demonstrate actual occupation. On the facts, Tina has been living in the property for 2 years, which satisfies the requirement for a physical presence. There must also be obviousness or knowledge. Tina's occupation must have been likely noticeable during a reasonably careful inspection of the property, which could include signs of habitation like furniture or personal belongings. Based on Williams and Glisbang and Bolin, a spouse in actual occupation was not recorded on the title, but the court upheld her overriding interest due to her physical presence. Tina's physical occupation on property is critical to her claim. If Charles validly granted her lease, her actual occupation could bind you as the new owner. Furthermore, based on Chokar and Chokar, a wife temporarily absent from her property due to hospital stay was still held to be in actual occupation, which gave her an overriding interest. This case demonstrates how physical occupation is interpreted broadly. Tina's continuous occupation for 2 years could strongly support her claim for an overriding interest. This can be distinguished with Lloyds Bank and Rosette, in which actual occupation requires a physical presence and mere intention without the presence is insufficient. If you can successfully prove that Tina did not have a clear and obvious physical presence, you may refute her arguments of an overriding interest. Finally, as seen in Abbey National Building Society and Cannes, the timing of an actual occupation was crucial in determining whether an overriding interest existed. The court emphasized that the occupation must have been established at the time of the purchase. Tina may argue that her occupation was present and evident at the time that you acquired the property for her lease to qualify as an overriding interest. An option to purchase is a proprietary interest, recognized in the case of Spencer and Duke of Marlborough. To prove that David has a proprietary interest and his option to purchase, David must further demonstrate that his actual occupation can be seen in Pineview Cottage. This is because under Section 27 subsection 2B1 of the LRA 2002, options to purchase must be registered at the land registry as a charge or a notice to bind future purchasers. If the option is not registered, it is generally not enforceable against subsequent purchasers who buy the property in good faith, as seen in Section 29(1) of the LRA 2002. The enforceability of David's option to purchase depends on whether his interest is properly protected under the LRA 2002. For an unregistered interest like David's to override your title, it must meet the criteria under Schedule 3, particularly paragraph 2, which is under actual occupation, as we previously discussed. David would need to show that he was in actual occupation of Pineview Cottage at the time of your acquisition of the property. Thompson and Foy clarifies that the occupation must be present at the time of the transfer. As we previously discussed in Abbey National Buildings Society and Can, the court emphasized that the occupation must be established at the time of the purchase. And as previously seen in the discussion regarding Stina's lease, actual occupation, it must have been likely noticeable during a reasonably careful inspection of the property. In this case, David does not appear to be in actual occupation. His claim of an option to purchase is contractual and unaccompanied by any evidence of a physical presence. Furthermore, if you had made reasonable inquiries about the unregistered interest and David failed to disclose the option, your title is further protected under Schedule 3 paragraph 2b, as David's claim was neither visible nor disclosed at the time of the sale. You are unlikely to be bound by it. Furthermore, in Midland Bank Trust Co. and Green, an unregistered option to purchase was held unenforceable against a subsequent purchaser who acquired the property for value. This demonstrates the importance of registration for enforceability, which David clearly failed to do. Thus, proprietary interests like David's option to purchase can bind subsequent purchasers if properly registered, or if they fall under the category of overriding interest. Under Section 32 of the LRA 2002, David could have protected his interest by entering a notice in the land registry. Without such registration, his option does not bind you under Section 29(1). Due to the priority rules under Sections 28 and 29 of the LRA 2002, which govern how unregistered interests are treated in the context of registered land, David's claim would likely fail without registration. Section 32 also allows for entry of a notice in the land registry to protect certain interests in the land, including equitable options to purchase. If David's option to purchase had been recorded as a notice, it would serve as a formal recognition of his claim, making it binding on subsequent purchasers like yours. Since no such notice appears in the registry, you as the registered proprietor is protected under Section 29(1). Without registration, David's option does not have priority over your title. In summary, while your registered title provides you with a strong legal protection, you must remain cautious of the overriding interests. Firstly, Tina's lease benefits from stronger protections. Her claim, supported by her continuous actual occupation, aligns with the conditions of the overriding interest under Schedule 3 paragraphs 1 and 2. As academics highlight, the overriding interest provisions serve as a necessary compromise to safeguard occupants' rights while maintaining the integrity of the register. Tina's lease as a proprietary interest holds strong potential to qualify as an overriding interest. Conversely, David's failure to register his option to purchase under Section 32 means his interest lacks priority under Section 29(1), rendering unenforceable against your title. Without proper registration, equitable interests such as David's fall short of the protection afforded by the mirror principle of land registration. David's claim to an option to purchase Pineview Cottage highlights the pivotal role of the mirror principle in land registration. The mirror principle, a cornerstone of the LRA 2002, ensures that the land register should provide an accurate and complete reflection of all interests affecting the land, ensuring clarity and transparency for purchasers, in which David did not do. Thank you very much for listening to my presentation. I hope this has clarified all your legal worries. If you have any further inquiries, do reach out to me as soon as possible, Alan. I will be seeing you soon. Thank you.